Welcome. Welcome to Frank Bruno Law. I am Frank Bruno. How do I define myself? I am an elder law attorney. I'm a guardianship attorney. I'm a senior attorney. I handle probate, guardianship, elder law, estate planning, right? I'm concentrated in that area. What else do I do? Well, I remain a servant of the court, and I get court appointments in a few different aspects of guardianship. I get court appointments from the surrogates court. And then I get some appointments, and I've had appointments for a number of years in the Supreme Court. What's an appointment? Well, a judge is involved in a case. He or she identifies that there's a need. So there's a child that needs a lawyer. There's an unrepresented party that needs a lawyer. There are unknown relatives that need to have their interests represented. Well, when a judge is confronted with that, the judge can look to a list of attorneys based on experience, submission of a resume and I want to say intake form, but there's a Part 36 list. If you Google this, Part 36 in New York City, you would see that there's a form to fill out. So I would put in when I was admitted to the bar, college, law school, classes that I've taken, what experience or expertise I may have in a given field. So that's really how you wind up being on that list, right? It's by legal skill, acumen, interest, right? If an attorney has no interest in representing children, they wouldn't put themselves on that list. If they have no interest in representing unknown people, they wouldn't put themselves on the list, right? So interest is a big part of it. And then if you have the interest in the field, you should, and I have, gone out and taken classes and mentored under other attorneys. You know, years ago, I'm a lawyer, 24 years now. I think my anniversary of opening my office just happened. I opened in 1997. I graduated law school in 95, and I opened up my practice in 97. So I kind of forgot what I was going to say today. I got sidetracked on how do I identify myself. I identify myself as an attorney that solves problems, an attorney that serves the court. A lot of what I do involves litigation, because if you can't resolve matters, you need to be able to go to court, right? So I always try and settle, always. And that's, well, there's a few different cases, right? So if I'm doing an estate planning case, I use my experience, what I've learned from the courtroom, what I've learned from will contests, what I've learned from families fighting, and I think ahead, and I include in any of my written documents solutions, methods to avoid conflict. Right, so I have this little slogan that I oftentimes use. There's either consent or conflict. Right, so you have consent, people can agree, settle, resolve, reach a stipulated agreement, negotiate. That's consent. Because when you have an agreement, you have to consent to it. You have to sign. You have to give an affirmative answer, right? Yes, I agree. That's consent. If there is no consent, there's conflict. And conflict follows a number of different paths. Outright disagreement, the position not to sign at all, position to ignore the offer presented, or even challenge the offer in court. So consent or conflict. I think that's what I'm going to call today's video. Without consent, there must be conflict. With consent, there is no conflict. Well, thank you. If you would like to reach a consent, reach out to frankbrunolaw.com.